Welcome, everybody, to the Women's Declaration International Australia and New Zealand webinar, September 2025. My name is Janet, and I'm the New Zealand Country Contact for WDI, and I will be your chair tonight. I'm also a policy convener for the Women's Rights Party, and I've been involved with a lot of gender critical activism in the last few years. Now tonight I have, we did have Janet Fraser with us helping us get started, and she's gone now. And I have the solicitor Bronwyn Williams, who I believe is from the Feminist Legal Clinic, just like Janet Fraser is, and she's going to help with some tech. So wherever you are coming from this evening, we bid you welcome. We pay our respects to elders past, present and emerging across Australia. We recognise Te Tiriti o Waitangi as the founding document of Aotearoa New Zealand, and we honour the women in both countries. Tonight we will be looking at a report from the New Zealand Law Commission which recommends adding gender identity to the Human Rights Act and weakening the sex-based protections for women. The report's title is Ia Tangata, a review of the protections in the Human Rights Act 1993 for people who are transgender, people who are non-binary, and people with innate variations of sex characteristics. We have 3 speakers who I will introduce in turn. A reminder that the presentation is recorded and question time is not. When we end for question time, I'd appreciate it if women use the Q&A box. You can see that at the bottom of your screen for written questions, so I don't lose them. If you wish to speak, please raise your hand icon, and I will write down who wants to speak. So I'm now to introduce our excellent panel. We have Jill Ovens from the Women's Rights Party, Fern Hickson from Resist Gender Education, and Jan Rivers from Sept. They will each be presenting the view of their organisations on the Law Commission's proposals. So I will introduce each speaker before she speaks. So now we begin with our first speaker, Jill Ovens. So Jill was one of the founding members of the Women's Rights Party and has been National Secretary and a co-leader since the party was formed, following the shocking violence at Albert Park at the Let Women Speak event, when no one got to speak. In the last year or so, Jill has been working with Janet, that's me, who is the New Zealand Country Contact, sharing gender-critical news and activities with other women around the world. Jill was president of the Alliance, a left-wing political party at one stage, and later she served on the National Council of the New Zealand Labour Party, as well as a range of local leadership roles within the Labour Party. She was a union leader and represented the different unions she worked for on the National Affiliates Council of the New Zealand Council of Trade Unions, including a time as a co-convener of the CTU women's sector. She also represented a large women's union at the Labour Party, where all the other union representatives were men. Jill has extensive experience in journalism and later taught journalism and public relations at the Auckland University of Technology. All the skills she has gained through these roles and other roles, including as a Lalish League leader and as a mother, have come together at this stage in her life in retirement in her work for the Women's Rights Party. Jill is going to talk about the Law Commission proposals from the point of view of women's rights. She is planning to focus on a potential claim to the Commission on the status of women, and so she will look at CEDAW, the Convention on the Elimination of Discrimination Against Women. So welcome, Jill.
Kia ora, everybody. This is, as Janet said, I'm Jill Ovens from the Women's Rights Party of Aotearoa, New Zealand. And we are a registered political party that focuses entirely on issues that directly impact women, girls and children. We advocate for women's sex-based rights so that these rights are respected and extended and not eroded. Our policy platform spells out our position in relation to women's sex-based rights. 1, the sex-based rights for women guaranteed in the Human Rights Act must be respected in law and policy, such as the right to single-sex spaces. 2, the Women's Rights Party is committed to the rights of lesbians to organise and socialise separately where they wish, recognising that lesbianism is same-sex attraction, not same-gender attraction. 3, biological males should not compete in women and girls sports, where there are issues of fairness and safety. And 4, the language in policy law, health and education needs to recognise that sexual orientation is about the attraction that a person can have either to their own sex, the other sex, or both sexes. Thus, at our submission to the Law Commission's issues paper last year, the Women's Rights Party, jointly with Women's Declaration International New Zealand, opposed the inclusion of gender identity as a protected ground for discrimination in the Human Rights Act 1993. We argued that adding gender identity to the grounds for unlawful discrimination would undermine the exceptions based on sex in Part 2 of the Human Rights Act. This is exactly what the Law Commission has recommended in its final 450-page report. In response to the Law Commission's issues paper, we pointed out that the question of whose rights would take precedence, that is, women's sex-based rights or new rights protecting men claiming identity as women, would inevitably have to be decided in a court of law. We are particularly concerned at the inclusion of self-determined legal gender recognition in the Human Rights Act. We do not agree that legal gender recognition equates to legal sex, which should be the biological sex recorded on the certificate at birth and which cannot be changed by hormones, surgery, or internal feelings, or, as the Supreme Court in the UK said, bits of paper. The Women's Rights Party and WDI NZ are committed to ensuring that New Zealand legislation reflects our government's commitment to the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. In Articles 1 and 5, CEDAW makes it clear that the women's rights it protects are sex-based and that women are subjected to discrimination from society on account of their sex. Reem El-Salem, the UN Special Rapporteur on Violence Against Women and Girls, explains it this way. In General Recommendation number 28, the CEDAW Committee defined gender as socially constructed identities, attributes and roles for women and men, and society's social and cultural meaning for these biological differences, resulting in hierarchical relationships between women and men. This understanding of gender clarifies that the term gender is not to be equated with women. She continues, while not addressing or defining the terms sex or gender, many foundational human rights treaties and declarations, including CEDAW, enshrine a prohibition of discrimination based on sex, which can only be taken to mean as referring to biological sex. In General Recommendation number 28, the CEDAW Committee reiterated that the objective of the Convention is the elimination of all forms of discrimination against women on the basis of sex. So any changes to the law which reduce or remove the protections on the grounds of sex, both the anti-discrimination provisions and the exceptions where discrimination is permitted on the grounds of safety, dignity and privacy, would be in breach of CEDAW. It's on this basis that we would complain to the United Nations Commission on the Status of Women should our government decide to proceed with the Law Commission's recommendations with amendments to the Human Rights Act. When it comes to women's rights, sex matters. When the Human Rights Act was drawn up in 1993 to comply with CEDAW, it was understood that sex meant women and men. In fact, if sex is to be conflated with gender identity, the sex-based exceptions that currently protect women's single-sex spaces of women's sports, among other sex-based rights, are meaningless. Sexual orientation, referring to same-sex attraction or opposite-sex attraction, is also meaningless if it doesn't refer to biological sex. This is the slogan of Sex Matters in Life, Language and Law. It shouldn't take courage to say so. And this is the slogan of Sex Matters, the UK-based organisation of which Helen Joyce is a director. Working with other organisations defending women's and girls' sex-based rights, the Women's Rights Party is bringing Helen to New Zealand on the 24th of October through to the 1st of November, when she'll be connecting with the Free Speech Union here. While Helen is on tour with the Women's Rights Party, she'll be talking about gender identity, the new battle for women's rights, the subtitle of the second edition of her book, Trans, Where Ideology Meets Reality. Helen couldn't have come at a better time. Her arrival in New Zealand comes hot on the heels of the release of the New Zealand Law Commission report Ia Tangata, recommending to the government that gender identity, or its equivalents in the cultures of the person, which the report suggests should be defined to include gender expression, and having an innate variation of sex characteristics be included as prohibited grounds against discrimination in the Human Rights Act. Currently, we have the prohibited grounds of discrimination are sex, which includes pregnancy and childbirth, marital status, religious belief, ethical belief, disability, age, political opinion, employment status, family status, and sexual orientation. These prohibited grounds are enshrined in the Human Rights Act, but also referred to under the New Zealand Bill of Rights Act and the Employment Relations Act. So any changes to the prohibited grounds under the Human Rights Act will affect these other laws as well. In fact, even if the coalition government decided not to implement the Law Commission's recommendations, and the Minister of Justice has said this is not a top priority for the government, so it won't be looked at until March next year, this report still exists and will be relied upon by government and non-governmental organisations to justify inclusion of gender identity, as they have done since the 2006 Crown Law decision, which said that gender identity is covered under the sex prohibition. So what does the Law Commission mean by gender identity? Well, the Law Commission includes definitions of gender identity as someone whose gender identity is different from the sex they were assigned at birth. What it means to be non-binary, that's someone whose gender identity doesn't fit exclusively in the male-female binary, and innate variations of sex characteristics that are said to differ from medical and social norms for male and female bodies. But the Commission rejected suggestions from several submitters, including the Women's Rights Party, to clearly define sex. The Commission says sex is a functional term that's used in different ways depending on the context. In the rare occasion they do use the term biological sex, they put it in quote marks, as if it's not real, whereas there are no quote marks at any stage around the terms relating to gender identity. The Commission also rejected submitters' suggestions that gender identity is a belief or ideology, saying that some people have a deeply felt feeling or experience of gender that doesn't match the sex they were assigned at birth. This is how they frame biological sex all the way through the report. Of course, we all know that sex is observable by 20 weeks gestation, by the presence or absence of testes in a penis, and can be tested well before that. The Law Commission claims that recognition of a person's gender identity is deeply embedded in our law, as well as the laws of other countries where we share a legal heritage. In fact, before the 2000s, gender does not appear in our legislation. For example, the Equal Pay Act talks about sex-based discrimination and makes no mention of gender. The table of provisions in other jurisdictions in the Law Commission report relies heavily on the Australian states and the Canadian provinces. The UK barely gets a mention, including the recent UK Supreme Court decision confirming that sex in the UK Equality Act means men and women in the ordinary meaning of the words. So the Law Commission here in New Zealand recommends inclusion of gender identity in the prohibited grounds, but no definition of sex. It is the worst possible outcome. This is because the Law Commission is recommending changes to the 19 existing exceptions in the Human Rights Act that allow people to be treated differently based on their sex, such as when accessing single-sex schools, sports, bathrooms, or shared accommodation. Their recommendations include amending some of the exceptions to clarify that transgender people cannot be excluded from spaces that match their gender identity, like gym changing rooms. In addition, the Law Commission is recommending that some exceptions be amended to clarify that they allow for differences of treatment based on a person's gender identity or their sex characteristics. They are suggesting new legal tests that should be met before this happens, as they have done in relation to women's sports. The Law Commission also made some suggestions about how to make some language in the Human Rights Act gender neutral. Of course they did. They recommend amending Section 74, which allows preferential treatment for women who are pregnant or giving birth. Only they're not women, according to the Law Commission. Although most people who become pregnant or give birth are women, not all are. Needs associated with pregnancy or childbirth exist regardless of whether the person who is pregnant identifies as a woman. Sex-based exceptions in the Human Rights Act include a Section 27 in relation to employment matters, which allows for different treatment based on sex, where being of a particular sex is a genuine occupational qualification for the position, or employment, for example, a counsellor, specialising in highly personal matters such as sexual matters or the prevention of violence. The exceptions in Section 27 include intimate situations that involve exposing one's naked body, such as showering or dressing the elderly or those with disabilities. The Law Commission has recommended extending this exception to include those with a gender identity and giving employers the discretion to manage relevant privacy issues, such as in a beauty salon where clients' pubic hairs are being waxed, or a store where bras are being fitted. Given that personal cares for the elderly, disabled or injured are usually provided through an agency, it would be possible for a client requesting to be cared for by a woman only to be sent a man identifying as a woman on the basis that the agency subscribes to the mantra, trans women are women. This is how the Commission explains it. The way social norms about nudity currently apply to gender identity is unclear. We suspect these norms are in a state of transition and that they mean different things to different people. We accept that for some old fuddy-duddies, no, actually it says people. These social norms mean their privacy is best protected if people of a different sex assigned at birth do not see their naked body without their permission. There are several sections of the Act that apply to single-sex spaces. For example, under Section 44, suppliers of goods, facilities or services to the public, they can't refuse to provide those goods or facilities or services to people of a different race or sex, for example. But notwithstanding this, Section 46 allows for suppliers of goods and services to provide separate facilities or services for each sex on the ground of public decency or public safety. The Law Commission recommends amending these exceptions to rule out service providers from excluding a person from a single-sex facility that aligns with their gender identity. Ironically, because we have sex self-ID in New Zealand, allowing people to change the sex marker on their birth certificate online without restrictions, the Law Commission points out that there is no current form of identification that reliably records a person's sex. Not that we would expect people to have to present their birth certificate when accessing public facilities. In a way, that's not what the issue is. The issue is we don't want men in our public facilities. And most men don't want to come in. It's the men who want to perv, who get their rocks off at being in a women's changing room in the gym or swimming pools. These are the men we don't want in there, that they identify as being a woman and have a certificate that says so. It makes no difference to us. They are men. The Law Commission acknowledges that submitters raise the issue of security risks for cisgender women and girls. We did, But we didn't use the term cisgender, of course. In a twisted logic, the Law Commission states, our research confirms that women are more likely to experience sexual violence than men, that sexual violence is usually perpetrated by men, and that many women have significant fear of sexual violence. However, we have not found evidence to support the concern that clarifying the legal entitlement of people who are transgender to use a single-sex facility that aligns with their gender identity exacerbates safety risks for cisgender women and girls. The Commission then goes on to say that some submitters raised issues relating to public decency, privacy, comfort and modesty. The Commission says it weighed these concerns against the harm to transgender people from excluding them from women-only spaces. They say women can always get changed in cubicles or toilet stalls, close the lid and put your clothes on the toilet seat and then try and get in and out of your swimming costume. It should be noted that all this is about men who want to identify as women. I don't think there is any barrier to women who identify as men going into either the men's or the women's facilities. This is a men's rights issue. There is just one place in the entire Human Rights Act at this time where sex is defined in terms of men and women, and this is in a section 47 in relation to skills. The section states that where the nature of a skill varies according to whether it's exercised in relation to men or women, a person does not commit a breach of section 44 by exercising the skill in relation to one sex only, in accordance with that person's normal practice. So you can advertise if your skills that you require are specific to either men or women. You can advertise for a man or a woman to fill a role. However, the Law Commission goes to great lengths to explain that this provision is about physical characteristics, for example, strength or height, and not one's sex. So they're recommending this section is rewritten. So the only place where men and women are mentioned is going to go if this gets through. The redrafting will make it clear that section 47 does not give effect to historical assumptions about limiting services to men or to women. And I have to say, I have some sympathy with this, as we've long had women in the police force and fire service, for example. And I can't think of any other place where particular skills would apply to men only. In section 49, we get into the relationship to sport, which is, of course, huge in New Zealand. It is lawful to exclude one sex from participation in any competitive sporting activity in which the strength, stamina, or physique of competitors is relevant. This doesn't apply to coaches, umpires, referees, sports administrators, or sporting activities for children under 12. It is also lawful to conduct competitive sporting activities or events in which only persons with a particular disability or age qualification may take part, like masters events or Special Olympics. No one quarrels about that. The Law Commission, however, recommends a new exception that would only allow sports organisations to treat someone differently by reason of their gender identity if this is reasonably required to ensure fair competition, to ensure the safety of all participants, and to comply with international rules of this particular sporting code. The Commission finds evidence concerning the participation of transgender people to be evolving and incomplete, and therefore couldn't recommend a blanket exclusion of men in women's sports or a total ban. The Commission places emphasis on broad community participation in sport without acknowledging that no one is saying men who identify as women can't play sport, just not in women's sports. Finally, we come to section 55, which relates to single-sex accommodation. Under the current Human Rights Act, hostels, hospitals, clubs, schools, universities, religious institutions, or retirement villages can provide accommodation only for persons of the same sex, marital status, or religious or ethical belief, or for persons with a particular disability, or for persons in a particular age group. As before, the Law Commission finds social norms about keeping men and women separate in shared communal accommodation are evolving. Even in situations where women and girls are vulnerable, such as women's refuges, the Law Commission finds no evidence that men who identify as women pose a safety risk. In fact, the Commission points out that all users of women's refuges are vulnerable, particularly transgender people who may have experienced gender-related violence. So our recommendations to this government would be as follows. 1. Don't touch the prohibited grounds of discrimination. Gender identity is an inner feeling experienced by an individual and has no place in law and policy. 2. Pay serious attention to CEDAW. We've signed up to it. We're obliged to abide by it. And the sex provisions of the Human Rights Act were written in order to comply with CEDAW. Any changes to the law which reduce or remove protections on the grounds of sex would be a breach of CEDAW. 3. Come up with a clear science-based definition of sex in law. 4. Make it clear that freedom of speech to question the concept of gender and to assert the sex-based rights of women is protected in the New Zealand Bill of Rights Act and must not be removed by any legislation, policy or government practice. 5. Repeal sex self-ID in the Births, Deaths, Marriages, Relationships Registration Act. 6. Remove gender from the Conversion Practices Prohibition Act. We support the aim of the legislation to protect lesbians and gay men from conversion practices and to promote open and respectful discussions about sexuality. However, the inclusion of gender, gender identity and gender expression in this legislation can reinforce conversion practices that aim to trans the gay away and also promotes gender identity to children that risks causing them permanent harm. 7. Pay some attention to the UK CAS review. In particular, that there's no evidence base to support the widespread social transitioning of children, which Jan is going to talk about. 8. Provide separate services for detransitioners who may be reluctant to engage in the very same services that facilitated their pathway to transition. This is in line with recommendations of the CAS review. 9. Provide safe, single-sex toilet and changing facilities in schools. The installation of mixed-sex toilets and changing rooms in schools is a failed social experiment that's harming children and young people. 10. Consider the rights of parents, and this is something that Fern will be talking about, to decide the educational needs of their children and adolescents, including the right to attend single-sex schools. 11. Consider the need for women to be afforded the dignity and safety of same-sex spaces when we're at our most vulnerable, including but not limited to toilets and changing facilities at work and at recreation, but also, of course, in prisons, refuges, rape crisis centres and hospital wards. 12. New Zealanders overwhelmingly support safety and fairness in sport at all levels. If clarification is required in relation to women's sport, it needs to be based on biological sex. 13. There shouldn't be any misgendering and dead naming in law. Restrictions in relation to names and pronouns have no place in the Human Rights Act or government policies. And finally, 14. Use clear and plain language when referring to women. In particular, we object to the term cisgender woman. We object to the suggestion that babies are assigned a sex at birth, and we reject to the use of gender-neutral pronouns. Thank you.
Oh, thank you very much, Jill, for that really extensive talk that covered so much of what the legal problems are in such a clear way. So our next speaker is Fern Hickson. Fern is a registered teacher with over 30 years' experience teaching in both primary and secondary schools. She helped establish Resist Gender Education, an alliance of educators and parents that advocates for scientifically accurate relationships and sexuality education. Since retirement in 2022, has continued to write submissions and lobby government ministers in favour of good quality RSE, which stands for Relationship Sexuality Education, which is the government's education program on those topics. So then we'll talk about the significant negative effects on schools if the Law Commission's proposals are adopted, and will bring us up to date on the status of relationships and sexuality education in New Zealand schools. So welcome, Fern.
Thanks, Janet. As Jill has explained, we cannot understate the significance of the Law Commission's report. If its recommendations are enacted, wishful thinking would be elevated to a human right. The Commission claims that its proposals are only minor changes that will have little effect on everyday life. But the changes are actually huge, particularly in education, where the rights of girls have been casually dismissed by the Law Commission. The report recommends that all single-sex schools be required to enrol any student who says their gender identity is the same as the sex category of that school. Currently, an exception under Section 58 of the Human Rights Act allows schools to exclude students who do not meet the criteria, where a school is maintained wholly or principally for students of one sex, race, or religious belief. The Commission has recommended the removal of the Section 58 exclusion pertaining to sex. Of course, it is girls' schools that will be most affected by this recommendation, not single-sex boys' schools. As far as we are aware, there are no girls who identify as boys wanting to attend boys' schools because of their obvious vulnerability if they did so. However, there are certainly several instances of boys already who claim to be girls who are attending girls' single-sex schools. Under the Commission's proposal, the number of boys wanting to do so is likely to increase. The Commission justifies this proposal by denying that having opposite-sex students in a single-sex school makes any difference. It says there would only be a handful of students, and having a few boys in a girls' school would not interfere in parental choice to send their daughters to a single-sex school. The needs of girls who might have chosen a girls' school because of shyness, anxiety, or past trauma simply do not count to the Commission. Allowing a boy into a girls' school also gives him permission to enter the girls' toilets and changing rooms, to play in the girls' sports, and to be considered for the girls' leadership roles, such as being head girl. When gender identity has the backing of the Human Rights Act, a transgender student can expect free access to facilities and opportunities that were not intended for them, and will be able to claim discrimination if this access is denied. In our submission to the Law Commission, Resist Gender Education warned of serious human rights issues if gender identity is given priority in schools. The Commission has only addressed enrolment policies and has not considered at all the implications in the daily life of schools if indefinable gender identity takes precedence over sex in law. There are many practical concerns: toilets and changing rooms, sports, awards, leadership roles, language usage, and freedom of belief. It is not safe or workable to ask schools to ignore the sex of its students or staff. Children do not have a choice about going to school. It is compulsory to attend, and quite often there is only one school available to them. They do not have a choice about school rules either. There is trouble if they disobey. So when a school requires students to pretend that a boy has become a girl, the school is enforcing an ideology and denying those students and their families their right to freedom of belief and freedom of choice. The Law Commission has decided that transgender children and young people are a particularly vulnerable group and recommends maximising their choice of school, a privilege afforded to no other group of students. Although the proposals are cloaked in human rights language, they undermine human rights principles by establishing a new special class of student, which has more rights than anyone else. Children who are not transgender have only two secondary school choices, single-sex or co-ed, and sometimes not even those two choices. Children who claim a gender identity will have three choices, either type of single-sex schools and co-ed as well. Even private religious single-sex schools will not be exempt from including transgender students. The Commission says requiring a religious school to enrol a transgender student is a justified limit on the right to manifest religion. On the other hand, a religious school would retain the right to refuse a student whose religious beliefs were not compatible. So we have the absurd situation where the Law Commission wants to make it unlawful for schools to discriminate based on the innate characteristic of sex, whilst permitting discrimination on the non-innate characteristic of religious belief. Apart from maximising choice for one group of children, the Law Commission did not reflect on any of the other effects its proposals will have on schools. Rather than consider the needs of all students, the Law Commission has given preference to the wishes of the few who believe that a person's sex is a matter of choice. This creates profound conflicts with our rights to freedom of belief and freedom of expression. The Free Speech Union in New Zealand has started a petition against asking the Minister of Justice to reject the Law Commission's recommendations in full, because they would limit legitimate speech, including by students and teachers. The Free Speech Union says conversations about sex and gender are unavoidable in many contexts, such as schools and workplaces, on topics like bathrooms, pronouns, uniforms and dress codes, or sports. These are areas where Kiwis should be free to express their views without fear of punishment. The Law Commission knows that concepts of sex and gender are currently highly contentious, yet it has still recommended that limitations on discussion of sex realist views can be justified in schools and workplaces. It says that New Zealand society places a high value on free speech, and up to a certain point, people are expected to bear speech-related harms. However, New Zealand law also recognises that in certain situations, free speech and related rights can be limited to avoid harm to others, including to protect other rights. The Commission has decided that misgendering of sufficient seriousness is one of those situations. It says that allowing misgendering would protect the free speech of some people, but at the expense of the equality, dignity and autonomy of people who are transgender or non-binary. The Commission says that how much protection is accorded to freedom of expression under the Human Rights Act differs, depending on the circumstances and the motivation. But it reports approvingly of some examples where teachers have already been censured for so-called misgendering. It envisages case law will emerge over time that will determine the balance between competing rights, but leaves us all hanging in the meantime. Without doubt, this will cause major difficulties in schools. The Law Commission has opened a can of worms for schools by pandering to the idea that pronouns can hurt people. It is quite happy to turn schools into a battleground of beliefs, or more correctly, to give preference to one set of beliefs over all others. Resist Gender Education advocates for schools to remain neutral spaces where everyone's point of view is respected, without others being compelled to profess agreement. Asserting that a student or teacher has changed sex or has become non-binary is denying scientific fact and should never be endorsed in an educational setting. There are multiple reasons why schools are not the place for gender identities or preferred pronouns. Humans cannot change sex. Asking children to use wrong sex pronouns is teaching them that some humans can change sex. Children do not have freedom of choice in schools. When a teacher role models using wrong sex pronouns, children will be coerced to follow suit, no matter their personal beliefs. Using wrong sex pronouns is extremely confusing and destabilising for new speakers of English and for children with intellectual disabilities or neurodiversity. Imagine being a junior teacher trying to teach children about the correct pronouns for singular and plural pronouns, and then trying to explain why a singular person is being called they. It's just so confusing and makes it really difficult to teach what is already a difficult language anyway. Using wrong sex pronouns gives subtle permission for children to enter spaces in sports that were reserved for the opposite sex. The concept of misgendering provides a whole set of new bullying opportunities, and even censure in some schools, against those children who make mistakes in preferred pronoun usage. This bullying can also extend to denunciation by students of teachers who do not agree with their demands. Children who have been routinely addressed with wrong sex pronouns will find it harder to reclaim their correct sex should they later resolve from a transgender identity. And this was reported in the Cass Review. Using wrong sex pronouns in schools embeds an ideological view not shared by the majority. Preferred pronouns and misgendering should be excluded from schools in the same way as other religious and ideological terminology is excluded. Resist Gender Education recognises that a policy to use standard English pronouns would go against the wishes of the Law Commission and some parents, but it is a rational policy that does not privilege anybody and maintains schools as places that teach scientific fact and are free from ideology. The Law Commission's report has elevated gender identity to be of more importance than sex, right at the time that our government is pulling back from this pernicious ideology. In February, the government removed the 2020 Relationships and Sexuality Education Guide that was riddled with gender ideology beliefs and provided an overhauled draft REC for community consultation. This draft included no mention whatsoever of gender identity and stated firmly that there are only two sexes and they are innate. The outcome from the consultation is due to be announced before the end of the year. Yet at the very same time as the Ministry of Education may be discarding the whole concept of gender identity, the Law Commission has produced a document that is adamant that gender identity is a deeply felt individual experience and that everyone else must acknowledge this to be true. What the New Zealand Government decides to do next is critical for protecting the integrity of our education system, as well as the human rights of everyone, especially the rights of women and girls. It is imperative that gender identity be given no status in law and no part in education, except as an example of how critical thinking has spectacularly failed, even amongst some of our most highly educated legal minds.
Thank you very much. That's wonderful. Very informative. Right, now our next speaker is Jan Rivers. Jan is a former public servant based in Wellington. She is the spokesperson for GenSpect in New Zealand. Jan's comments will be about the possibility that adopting the Law Commission report would embed a right to gender medicine despite the lack of evidence for it, and the way that such a law would make it even harder for medical data collection to return to sex-based recording. If adopted as proposed, a law based on the report would cut across the government's own policies. Jan thinks that there is questionable wisdom in implementing further legal protections in favour of transgender people when transgender activists can seemingly cancel people as well as public discussion and events. So, welcome, Jan.
Kia ora koutou, and thank you for the opportunity to come and be present at this tonight. My presentation will be a little bit looser than the other two, but hopefully informative and helpful. And Janet has introduced it very well. I'm going to use some slides, so I'll just share those now. First of all, what I wanted to say is that we have done a brief response to the Minister of Justice, Paul Goldsmith, and it's available on publicly published as well on the Substack site of GenSpect. So if you go to GenSpect Substack and then the New Zealand section, it's the latest item that's been put there. I just wanted to mention a little bit about what GenSpect is and what it does. So GenSpect is an international organisation founded in 2021, founded principally by psychotherapists, counsellors and the parents of children who were reporting as transgender or gender confused. It's now in, I think, about 20 countries. The New Zealand branch was founded in 2023. We founded with a webinar in November of 2023, and the video of that, and some of the transcripts are online and available from our Substack page. So GenSpec recognises trans identification as a mental health issue that really needs psychosocial supports. It advocates for ethical, non-medicalised responses to gender distress and raises awareness about the risks of inappropriate medication and promotes healthier outcomes for individuals, families, and broader society. There's one thing which I'd like to start by, because the other two speakers have mentioned this already, and it's about the capture of language in the Law Commission's report. And the Law Commission wouldn't be the first. In fact, my count comes to about 6 or 7, where a government agency has taken advice from a single perspective in order to create policy. And that has been done in our statistics department, in the Department of Internal Affairs, when the births, deaths and marriages law was implemented. It's happened in social welfare and the Oranga Tamariki, our children's ministry, and more. And it seems to me that there is an incredible level of one-eyedness about this kind of approach, to think that good policy is made by approaching only one side of the equation in an area of contested public policy. You don't ask employers about how to make law for workplaces. You don't ask just the landlords to make policy about housing. So, to me, that's a really sort of obvious problem. My presentation will cover what was in the letter. So it discussed the idea that it will embed gender medicine as a human right, despite the lack of evidence. As Fern has already mentioned, it will cut across current government policy objectives. There are the issues already mentioned about social cohesion. I'd like to talk a little bit about the incoherence that relates to the findings in the UK Supreme Court case that clarified the definition of sex for their Equalities Act, but which this Law Commission report has failed to do, and then talk a little bit about the growing level of opposition, largely in response to bullying from transgender activists, which means that this is not the right time to be thinking about making the kind of changes that are proposed. Right, so GenSpec's concerned about gender medicine are that it would embed the rights to gender treatment, despite the lack of evidence. It would mean that the medics would no longer be able to uphold the long-standing bioethical principle of do no harm. Of course, such treatment creates substantive risks to future fertility, sexual function, and physical health. This is becoming well known now, and it's likely to set children and young people on a lifelong path of medicalisation. Now, I haven't read the entire Law Commission report, although I read the issues paper 18 months ago several times. But one of the things that I have noticed in this report is that it takes very seriously the likelihood of fertility loss for young people with disorders of sexual development. But it doesn't make the same kind of comments about the likelihood of fertility loss or future sexual function for the young people who are asking for gender medicine. There's obviously increasing evidence of regret. It appears that gender medicine not only fails to prevent suicide, but it appears that it may be increasing the risk of completed suicides. So actually, what the people who tend to commit suicide and to have severely bad mental health with in the gender medicine area are those who are often being fully supported in their trans cross-sex identities. And just to point that one of the things that the Law Commission report does, and our own gender medicine, affirmative gender medicine, is to see trans children, not children with gender issues. And the whole idea of the creation of a trans child is a kind of a fascinating political success story by transgender activists. So why would it embed this? Well, first of all, one of the paragraphs in the Law Commission report says that gender affirmation exists and there are various treatments for it: clothing and changes, names and pronouns, legal gender affirmation, and medical gender affirmation. So we have it right there. This isn't about medicine as usually practiced. It's about medical gender affirmation, and it's also involves in our regime the whole idea of informed consent, which isn't the kind of informed consent that you usually have around medical interventions. It basically means we've told you what the impacts will be, and you kind of sign away your life to have this lifelong medical intervention. So the nature of gender medicine is there, identified as something that people with gender identities and non-binary people need. And then the Law Commission says that it would be possible for people to take cases to receive affirmative care. And these are the paragraphs that describe that. If a case, it sounds very sort of cool and clinical. If a case about access to gender affirming care was brought in Aotearoa New Zealand, the plaintiff would need to establish that they were treated differently on the basis of gender identity, and this caused disadvantage. And then the government would have the opportunity to establish that any discrimination was justified. And then we would expect medical evidence and clinical considerations would be central to the court or tribunal's analysis. And maybe we might even give some deference to medical opinion. The most likely situation where this would arise, if gender identity was included in the law, would be in recognition of the fact that that gender medicine is not good for people. And that has already happened in Alberta, in the States, and in the US Scrimetti case. There were legal challenges to the intent to limit access to gender medicine. In the US Scrimetti case, that was a United States Supreme Court case, that case was won by the 25 or 26 US states that wanted to be able to rein in puberty blockers for children and young people, and cross-sex hormones in some cases. And the case in Alberta, Canada, the government has legislated to reduce the ability of young people to get puberty blockers, and there's now a legal challenge. So we don't want to create the situation, and as Fern said, we don't really want to create laws for which the end result is endless litigation and lawfare. We want to create laws where the intent is as clear as possible and the definitions are as clear as possible. And the reason why you would go to law is because of unanticipated circumstances, not because the law has been poorly drafted. So this is where I see the problem is that if a government saw that there was a problem with gender medicine, they would be highly incentivized to do nothing about it. And then just a little reminder about what's happening with our affirmative care at the moment, which is it's incredibly difficult to comment in New Zealand about the problems of gender medicine. Professionals who do invariably face censure. If psychotherapists, counsellors and psychologists are actually barred by their professional associations from doing other than affirm transgender identities, irrespective of the kind of explanatory logic of where a transgender identity comes from. And it seems to me there the issue is, would you assume that a transgender identity comes in some cases from social contagion, from classmates and school friends, as in the same way that for young women, things like anorexia, self-harm, and so on have arisen? Or would you think that suddenly people are discovering en masse their real selves, their full integrity, and that full integrity is realized as somebody who's in the wrong body? I mean, to me, the explanatory power of one is much, much greater than the other. So the threat of a discrimination case based on not providing care would have a chilling effect. So we wouldn't even have to have a case. We would just have have to have the threat of a case, and it would embed even more deeply than we have at the moment the idea that gender medicine is a legitimate kind of medicine and that it should be provided to those who want it on an informed consent basis. From GenSpec's perspective, if you like, the way that this Law Commission report has been constructed is that it takes a partisan view. And like I mentioned before, the Commission's working group consisted only of people seeking to maximise the rights of transgender people and non-binary people, but not seeking to consider other rights. This is about the definition of sex. This is what the Law Commission said. We set out our understanding of the different ways the term sex is used in fields such as biology, medicine, and law. No meaning that could be given to the word sex can justify denying people protection from discrimination based on their gender identity. I mean, this kind of language really shows the extent to which the inputs into this whole effort were one-sided. I'd like to just demonstrate the sort of extent to which the Law Commission has taken on the transgender view. I looked up the word, the different words for the definition of non-binary, and by coming up with that, I came up with a whole list of other words for non-binary across multiple different languages, and it included the word anoyedd, which is the Welsh apparently for non-binary, and I did a bit of background research. It seems to have suddenly appeared as a neologism in 2022. It has no existence in any dictionary before that. And yet our transgender community were able to convey that information to the Law Commission for them to faithfully reproduce it in their Law Commission report. Fern mentioned the way that what happens with the Law Commission report is that the government has a certain amount of time to consider it and to consider whether to adopt it as a whole, in part, or to set it aside. And as Fern said about education, what would happen is that the report goes directly against what's currently happening in education with the removal of gender identity issues from the new curriculum. But there are other areas where the same thing would happen. So our government has decided that it will retain terms, sex-based terms for women in the health sector, instead of terms like cervixes, pregnant people, and chest feeding. And I don't know, I've got TA there, the Ministry of Health has recently suggested much more cautious approach to gender medicine for children and young people. And the government is currently consulting on changes to Public Services Act. And when the Labour government implemented the Public Services Act, it had a requirement for boards and chief executives of government departments to implement diversity and equity across their agency. And what's happened with that has been that gender ideology organisations have had a place at the centre of government influencing policy. So these organisations that have very little respect for public sector norms have been right at the centre of our government. The current National Party are proposing to remove those guidelines about diversity and equity. But of course, the Law Commission report would go completely against that. So basically, if the gender identity legislation were put in place, it would be difficult to legislate in these and possibly a number of other areas. One of the things which came up in the UK Supreme Court case was a discussion about the coherence of the law, that if you had sex meaning two different things, essentially the law could not be coherent. And this was from an article written by on a Substack called Void If Removed, and it was a description of the meaning of sexual orientation if the Scottish Government's assessment of what sex meant was put in place. And basically it meant that sexual orientation became meaningless. and you don't need much imagination to kind of think about how that works. But basically, if a man changes sex or changes gender, his partner is then a lesbian. He is then a lesbian. You know, it's sort of if a young woman transitions to male, is her female partner then a heterosexual young woman? Is she now, if her partner is also a trans man, are the couple, the couple of young women now a gay couple? That's the kind of thing, the incoherence that would be brought into our public policy if we go ahead with this Law Commission report. The thing that I wanted to mention about social cohesion is that transgender and non-binary people and the whole transgender movement have accrued considerable public power. They can apply considerable pressure to public servants. And organisations, as I mentioned, like in the caring professions, are pretty much unable to provide other than affirmative care. So it seems to me that it's dangerous at this stage to think about implementing this Law Commission report. And what I've got here, this next slide, is these are two surveys taken 4 years apart by YouGov in the UK, and they are a summary of British attitudes to transgender rights taken 4 years apart. And on the right-hand side is the earlier one, and on the left-hand side is the more recent one. And basically, I think what's happening is that as the kind of no debate has come to an end across the world, but specifically, particularly in the UK, as people start to understand what the demands of self-identification and what the demands of the transgender movement are, they're becoming less and less acceptable. So this isn't about transphobia or fear. If you look at the top, should people be able to identify as a different gender than the one recorded at birth? People are pretty much relatively happy with that, but it's the other areas where this impacts that are starting to become very contentious. Yeah, there's just a really good article about the bullying and cancellations that's happened, which I recommend you to. But basically, if you're going to implement law that sees people imprisoned for misgendering or fined, as is happening in Canada and Australia at the moment, you're going to be implementing a law that reduces social trust and reduces the idea of the idea that we have common interests and that we look after each other rather than that we are opposed to each other. And I just think that's extremely dangerous. Finally, and this is my last slide, I was hoping to put some links here to some of the other really good written material that's been put out. But in particular, Annie O'Brien, who used to be the spokeswoman for Speak Up for Women, has written 2 magnificent articles. And a former judge, David Harvey, is going to be writing an in-depth analysis over the next 3 or 4 weeks. And a Substack called The Ministry Has Fallen has also written a good piece on why we should be opposed to the Law Commission report. So that's me. Sorry, I've gabbled a bit, but thank you for the opportunity to come and talk about this.
Oh, thank you very much. That was wonderful, Jan. And it's great the way the 3 speakers have all covered different areas, which are all really important. And terrible to think what might happen to our young people if we go further down this track. So that concludes our excellent speakers. So thank you very much, all of you. And thank you to everybody for coming along to listen. And we are now moving into question time. And we can have a discussion, and we have some written questions, so we'll look at them first. And if you have more questions, you can write them in now in the Q&A.